Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. And as always, this is my private Facebook group, which you can join us if you're in foreclosure, and we'll try to help you. It's 219 members right now, and we're all sharing very helpful information with each other. So let's talk about today what our topic of the day is, and that's some foreclosure cases that every fighter should have in their back pocket. So let's talk about what they are. Okay, this one's a pretty good one. This came out of Alabama, and it's called Horace versus Lasalle Bank. And we'll just kind of go over this real quick so you guys get the gist of it, but it's a good one to always have to cite because it's one of those ones where the homeowner wins, sort of. You know what I mean? Okay, so it's saying an Alabama Circuit Court ruled in Russell County has issued a summary judgment this week in the case of Horace versus Lasalle Bank, preventing the bank from foreclosing due to irregularities with the assignment of a promissory note. The ruling prevents defendant Lasalle Bank, as the trustee holding the plaintiff's securitized mortgage, from proceeding with the foreclosure because the trust failed to follow its own pooling and servicing agreement and did not follow applicable New York law when trying to obtain assignment of Horace's note and mortgage, according to the court order. Without proof, the mortgage had been assigned to the trust, in this case, a Bear Stearns-related mortgage trust. The trustee lacked standing to foreclose, the court found. Specifically, the homeowner alleged that Lasalle only produced a collateral file that included the original wet ink signed note in the case, according to the court records. That note contained a single endorsement in blank which came from the originator of the mortgage, which was Encore Credit Corp. While the loan was sent through a securitization process going through two other parties before reaching the trustee, the only assignment on record was from Encore. Accordingly, the endorsement chain does not comply with the required by the PSA, Judge Albert Johnson wrote in an order granting summary judgment and permanently enjoining Lasalle from foreclosing on the property, a home in Phoenix City, Alabama. The court is surprised to the point of astonishment that the defendant trust, Lasalle Bank National Association, did not comply with the terms of its own pooling and servicing agreement and further did not comply with New York law in attempting to obtain assignment of plaintiff's Horace's note and mortgage. The judge's order, signed March 25th and filed with the court Wednesday, and this was in 2011, guys, so just so you know. Horace is a third-party beneficiary of the pooling and servicing agreement. Without such, plaintiff Horace and other mortgagors similarly situated would never have been able to obtain financing. Horace's attorney, a guy named Nick Wooten, said that the judge's decision proves that the securitization process totally and completely failed, and that many of these assets were not transferred. It does not mean that the party gets a free house, however, he said. Rather, Wooten said that the issue is allocation of real losses, and the next step would be to determine who is the proper foreclosing party. But Sean Ramey, an attorney representing Lasalle Bank, said the ruling contradicts existing court opinions, and he believes that the issue should be resolved later on appeal. They opposing attorneys say this does not mean the person gets a free house, but my response is it sure looks like that became my client holds a note and they can't foreclose. He added that the note holder can't foreclose. Then he calls into question who can foreclose. Ramey said when he removed the securitization issues from the case, he believes under Alabama law the actual holder should have absolute foreclosure rights. The Lasalle ruling seems to contradict other Alabama cases, he said, namely U.S. Bank versus Congress. In U.S. Bank versus Congress, an Alabama judge ruled that a former homeowner challenging a foreclosure had no third-party standing to challenge the terms of the pooling and servicing agreement connected to the trust. Ramey said he believes cases are similar. The most surprising aspect of the Lasalle case, of the Lasalle order, is that the holder suggests that the mortgagor is a third-party beneficiary to the pooling and servicing agreement, Ramey said. He believes the recent decision definitely shows there is no defined rule. But for Wooten, The homeowner's attorney in the latest decision illustrates just how deep the nation's securitization issues go. There were thousands of documents moved where there is no chain of assignments, Wooten said. The problematic side is what are we going to do about that fact that this didn't occur? My only wish after being in this fight for the 3.5 years is that we will get an honest evaluation of what's really wrong so that we can, as a country, go back on our feet. If we don't get control of servicing, they will drive us into a depression that will take 20 years to get out of. This case involves certificate holders of Bear Stearns Asset-Backed Securities 1 LLC, Asset-Backed Securities Series 2006, EC2. It also names as defendants Mortgage Electronic Registration Systems, Encore Credit Corp, EMC Mortgage, and Bank of America. So this is an interesting case, guys, and you can find it by Googling it, but it's if you Google Horace versus Lasalle Bank, you'll be able to bring it up. And another good case to look at is the Glaski versus Bank of America case. Let's talk about this one real quick. Okay, in this case, Glaski versus Bank of America. This is the proceedings, and you can also Google this case. It's very easy to find. In October of 2009, Glaski filed his original complaint. In August of 2011, Glaski filed the second amended complaint, which alleged the following cause of action. Fraud against J.P. Morgan and California Reconveyance for the alleged forged signatures of Deborah Bricknack as vice president for California Reconveyance and then vice president of J.P. Morgan. Fraud against all defendants for their failure to timely and properly transfer the Glaski loan to the WAMU Securitized Trust and their representations to the contrary. Quiet title against Bank of America, Chase, and California Reconveyance based on broken chain of title caused by the defective transfer of the loan to the WAMU Securitized Trust. Wrongful foreclosure against all defendants based on the forged signatures of Deborah Bricknack and the failure to timely and properly transfer the Glaski loan to the WAMU Securitized Trust. Declaratory relief against all defendants based on the above acts by defendants. Cancellation of various foreclosure documents against all defendants based on the above acts by defendants, and unfair practices under California Business and Professions Code Section 17200 against all defendants. Among other things, Glaski raised questions regarding the chain of ownership by contending that defendants were not the lender or beneficiary under his deed of trust, therefore they did not have authority to foreclose. Okay, so, I mean, this is a very lengthy kind of thing to read, guys, but I wanted to go over a couple of points that were very important. Okay, so it's saying here in the Glaski case that the allegation that the WAMU Securitized Trust was formed under New York law supports the conclusion that New York law governs the operation of the trust. New York Estates Powers and Trust Law, Section 724, provides, if the trust is expressed in an instrument creating the estate of the trustee, every sale, conveyance, or other act of the trustee in contravention of the trust, except by authorization by this article or any other provision of law, is void. So that means that if the assignment is made after the trust closing date, that makes the assignment void. So that's the whole thing with this one, guys. And it gets into it even more here, where it's saying, under New York trust law, every sale, conveyance, or other act of the trustee in contravention of the trust is void. Therefore, the acceptance of the note and the mortgage by the trustee after the date the trust closed would be void. Now he's quoting Wells Fargo Bank N.A. versus Eurobobo. And that's a 2013 case. Under New York law, any transfer to the trust in contravention of the trust documents is void. So basically they're relying on the Eurobobo case. A bankruptcy court recently concluded that under New York law, assignment of the Salvador's note after the startup date is void ab initio. As such, none of the Salvador's claims will be dismissed for lack of standing. So we conclude that the Glaski's factual allegations regarding the post-closing date attempts to transfer his deed of trust into the WAMU securitized trust are sufficient to state a basis for concluding the attempted transfers were void. As a result, Glaski has stated a cognizable claim for wrongful foreclosure under the theory that the entity invoking the power of sale, which was Bank of America in its capacity as trustee for the WAMU securitized trust, was not the holder of the Glaski's deed of trust. So they couldn't take his house. Again, that's a very important case, guys. I hope you all find this interesting and helpful. If you're fighting foreclosure and you have questions, maybe you have a mortgage that was securitized and you're fighting your own quiet title action. If you have questions, you can shoot me an email. My email address, foreclosurehelp777@gmail.com. I'll be happy to answer any questions you might have. I hope everybody has a wonderful day and God bless.